Good evening, everyone, and thank you for joining our Housing Rights Clinic. My name is Skip Koenig. I am the Director of Pro Bono at Neighborhood Legal Services of LA County. We are right down the street from Assemblymember Rivas's office in Pacoima, and we really appreciate the opportunity to put on this workshop and give you an update on the recent changes to some of the housing laws in the city and county of Los Angeles. Just briefly, anybody, and we'll repeat this at the end, if any of you have specific questions about your housing issues or any other issues that you may, other legal issues you may have, please feel free, and we welcome you to reach out to Neighborhood Legal Services. You could either do that online at www.nlsla.org, or call our intake number at 800-433-6251. In addition to housing work, we provide free legal services in the areas of immigration, healthcare, workers' rights, clean slate, a number of legal issues across the spectrum. And with that, I am going to turn it over to our host, Assemblymember Luz Rivas.
Thank you. Thank you, Skip, and thank you, Neighborhood Legal Services, for partnering with me to host this workshop. I'm Luz Rivas. I'm proud to represent the 43rd Assembly District, which is the East San Fernando Valley. I've been elected since 2018, and I'm excited to serve my community in the legislature. So thank you to all community members who have joined us tonight to want to learn more about your housing rights and tenant protections. During the pandemic, a lot of our community members faced significant hardships. In the early months, millions of people unfortunately lost their jobs and some of them their own home. Many of my constituents were unemployed because of the pandemic, and many turned to our state for help and applied for unemployment insurance. My district staff was on the job, responded to thousands of constituents. Just in 2021 alone, my district office assisted more than 1,000 constituents in receiving their EDD payments, which enabled them to pay their rent, to buy food for their families. We took this very seriously. This is why I'm in office. This is why my team works for the state assembly, because they want to help constituents, especially when they're most in need. And we fought to get those EDD payments to our constituents as fast as possible, because we wanted to make sure that no one lost their home, that they were able to buy food for their families, and get the money that they needed right away. In the legislature, I have always supported tenants' rights bills. I work on legislation related to homelessness. I've co-authored bills that are related to affordable housing, creating more affordable housing in our state, especially here in Los Angeles County. So this legislative session, I introduced AB 799, which aims to include more accountability in our homelessness funding so that we can see the results of the funds that our state is spending locally on homelessness. And then I've also, like I said, co-authored other bills in the past. A few years ago, one that created more rental caps so that landlords aren't able to raise your rent by over 10%. And very proud that that passed, and that we are that no one will get evicted, right? Because they can't afford their home. And that's why I'm here. I'm excited to partner with Neighborhood Legal Services to make sure that people are aware of their housing rights. I mean, we have found that a lot of people are not aware of that they have rights as tenants, and that, I think it's important that people understand what they can and can't do and what their landlords can and can't do by our state laws. So thank you again, Neighborhood Legal Services, for partnering with me, for offering this workshop tonight. I know a lot of people are probably busy getting home from work, making dinner, but this topic is so important. And I get calls from constituents all the time asking questions that I know will be answered tonight. Now I would like to introduce Michael Novarski from Neighborhood Legal Services to begin the evening's presentation. I know this workshop will be so informative, and I want to thank Michael for taking the time today to present this information. Thank you.
Thank you as well. And thank you to everybody who's here tonight. So I'm going to share my screen so that you can see this presentation. One moment. Before we get started, there will be Spanish interpretation for anybody who needs it. Instructions will be in the chat if you need them as well to how to access that. But if you look at the bottom of the screen, there should be a globe sign. And if you click on that, you can access the other channel, which will be for Spanish version of the interpretation of this presentation as well. Getting started. So what we're going to talk about tonight is your rights and protections as a tenant. Specifically, what we're talking about is protections that you have that prevent you from being evicted or can help in that situation. So to get started then, I do want to talk briefly about what an eviction is. So when a landlord wants their tenant to move out of the home or the apartment that they live in, then they have to start a court case against them. This court case is called an unlawful detainer. That's a term you might hear frequently, and this is what it's referring to as an eviction case. So the reason that landlords have to bring that case is because they're not allowed to change the locks or to stop a tenant's utilities or interfere with them on their own. Only a sheriff can evict somebody in California, and the sheriff can only do that after they're given permission by the court through this unlawful detainer process. So moving forward, the reason that people might find themselves being evicted is typically when something they've done is wrong or something they've done that has violated a lease. So some common reasons here are if the tenant hasn't paid rent to the landlord, this is a reason they might see an eviction. Another one is if they've violated a term of the lease. So this can be a number of reasons, and it depends completely on the lease that you have because everybody's lease is different. But usually what you're seeing here is that there's something in the lease that prevents you from the tenant from doing something. So there's a clause in your lease, for instance, that says the tenant is not allowed to have a pet, or it can only have 4 occupants in the apartment. And then if you then have a pet or have more than 4 occupants, the landlord will claim that you violated the lease. Not everybody who lives in a home or apartment who rents one has an actual written lease. And so in those situations, the landlord's going to have a hard time saying you violated something because there's nothing preventing you under the law from having a pet unless you agree to that with your landlord. Other reasons people might be evicted is if there's significant damage to the rental property, which we call waste. This is not just minor damage, but significant damage, like a pipe has burst and there's water everywhere, which has damaged the property significantly, or there's large holes in the walls, or things like that would be waste. Other situations are if the landlord is claiming that you are disturbing other tenants or neighbors, they're claiming that you're a nuisance. So this could be through excessive noise, like loud music late at night. This could be fighting with neighbors or tenants, things like that. So they're claiming basically that you're causing a nuisance to other people nearby. Similar to that is illegal activities. This doesn't mean any law that's violated. It generally means specific things like if you or somebody in the household might be selling illegal drugs, that could be an illegal activity that supports an eviction. It could be if the tenant is engaging in like illegal gambling or like a gambling ring or prostitution or something like that. Those are the types of illegal activities that it's talking about, not just any illegal activity. The final reason is one under state law. Actually, the landlord, just if the lease is expired, they can have no reason at all. They can just decide that they want to end the lease and move on. The reason we're having this presentation is because there are other laws, not just the state ones, but laws put on by the county or the city that prevent these types of evictions. And so we're going to talk about those specifically. So I want to talk, before we get to that though, about how a legal eviction moves forward and what steps it takes. So the very first step that a landlord has to do before they even start the unlawful detainer, the court process, is they have to serve a notice on the tenant. There are many types of notices and many lengths. And so what I mean is the language here is an example of one, which is a 3-day notice to pay or quit. This is the type of notice that a landlord will serve if they're claiming that you owe rent. There are other types of notices you might see as a perform or quit notice, also a 3-day notice usually. And this is the type of notice the landlord would serve if they're claiming that you violated the lease. They could also serve longer notices like 30-day notices or 60-day notices. So it just depends on the type of claim they're bringing. But no matter what they do, they have to start with this notice. This is not an eviction notice per se. It does not mean that within 3 days you're going to be evicted. This is just the first step of the process. Its purpose is to tell you what the problem is, like if you owe rent, for instance, or if you're breaching some part of the lease. And then it's also supposed to give you the right to fix whatever that problem is. That's what the 3 days refers to. So if, for instance, they give you this 3-day notice saying you owe a month of rent and you really do owe it, then you can pay it within those 3 days, and then the landlord can't do anything further. They can't bring a case against you. So that's what I mean by it gives you the right to fix it. But this notice is not really just a warning, because what it does tell you, or a tenant, is that the landlord is planning to start an eviction case against you. So this is the first stage in the proceedings, and probably the first time that you might want to contact an attorney or somebody else to discuss what rights you have. Because if you can prepare, you might be able to avoid a case being started against you completely. The next step, once they've served that notice against you, we'll say it's a 3-day notice, and those 3 days have passed. They have to wait until they've passed. But once those days have passed, then the landlord can serve a summons and complaint. There's a picture here, which is an example of what that looks like. It's not like the notice, which might be something that the landlord just wrote, but it's actually an official court document where they're stating to the court basically that they gave you 3 days or however much time to fix the problem, and then you didn't do it. And so now you're unlawfully detaining the apartment. You're living in there without a right to live there. If you receive this document, this is crucially important to take action quick, because you have 5 court days to respond. What I mean, first of all, by court days is business days, basically. It doesn't count weekends or holidays, but you do have to respond within 5 business days. If you don't, you may actually lose the chance to defend your case at all, and the landlord might be able to evict you without you ever telling the court anything or putting on any defenses. You do have the right, though, to respond, to file. The way you respond is by filing an answer. And this is your ability to tell the court what defenses you have, or really why you should not be evicted. So again, it is important that you do that within the 5 days set of receiving this summons and complaint. So go to the courts. They have self-help centers that can help you file those. Speak to an attorney. You can call us. We can help give you advice on how you might be able to answer that. But make sure you do something. Do not wait. Now, like I said, the answer is your chance to tell the court why you should not be evicted. So some reasons that you might have are, for instance, if it's the landlord's claiming you didn't pay rent, well, you can tell the court that I don't owe that rent, or I don't owe as much as the landlord's saying I do. If they're claiming that you violated the lease, you broke the lease, you can say, I didn't break any rules at all, or that rule doesn't exist. Remember, like I said earlier, if you don't have a written lease, then the landlord they might be trying to say you broke a lease term that you never agreed to. They can't evict you for that. You can also tell the court a couple of other types of defenses, that come up a lot, I think, are retaliation. You can say that the landlord's really just bringing this case. I don't actually owe any rent, but the landlord's just bringing it against me in retaliation, basically because I made a complaint against them or I asked them to make repairs and they didn't like it. So the only reason they're bringing it is just to punish me. Along those same lines, you can raise claims of discrimination, where you can say that, tell the court that the landlord's only bringing this case because they're targeting me based on my race, my national origin, religion. Disability is a frequent form of discrimination landlords might engage in, and a whole other things. These are just some examples that I've put on this slide. There's many more categories that they could be targeting you based on that you're protected from. Or any other reason. Obviously, there's a whole host of defenses you might have. These are just some of the main ones. And this is what you put in your answer. Once you file the answer, the cases move very quick. So you have to be prepared and start getting ready for a trial that's going to happen. What'll come next is the court will send you something in the mail. Usually it's a notice that'll say what your court date's going to be. And that court date is actually going to be your trial. You might have a trial the first time that you're ever in court before ever meeting the judge, and you might have to put on a trial that day, so be prepared. That trial usually will be assigned, you'll have that court date about 3 or 4 weeks after you've filed the answer, so a month or just less than that. You can ask for more time, by the way, on a trial, but typically you should be prepared to start the trial that day. When you get into court that day, 2 things can happen, basically. One, either you go to a trial and the judge or a jury will decide your case, determine whether or not you or the tenant or whatever should be evicted. Or you can speak to the landlord's attorney or the landlord themselves and negotiate some sort of settlement, which gives you, you can come to an agreement basically on whether, there's a whole range of things you could do in a settlement. So you can agree to pay whatever money you owe and stay in the apartment. You can agree to, usually, honestly, what happens is the landlord will want the tenant to agree to move out of the apartment, but do so without having an eviction at all, and certainly no court case on their record. So those types of deals can be reached too, depending on, how you are able to negotiate with the landlord. If you do go to trial, what can happen is you either win, basically, or the landlord wins. If you, the tenant, I use you as the tenant, wins, then the tenant gets to stay in the apartment, first and foremost. There might be some conditions on that. So if the court decides that you do owe some rent, but not as much as the landlord said, the court might allow the tenant to stay in the apartment as long as you pay whatever amount is owed. So there could be some conditions, but the basic idea is that the tenant wins and they get to stay, they remain a tenant of the apartment. If the landlord wins, that's when the eviction notice actually can come. So at that point, the sheriff has given permission to evict the tenant, and they will post this notice, which is an actual eviction notice, a notice to vacate, giving the tenant warning of about 5 days before the sheriff is going to show up. Once this notice shows up on your door, that means that a case has already happened. And if you haven't appeared in the case or filed any papers, you should definitely speak to an attorney right away to see if there's anything you can do to make sure you get that answer in. Because once you receive this, like I said, the sheriff will show up in about 5 days, maybe 10 days, somewhere in that range, and change the locks on the apartment. And that'll be the eviction. So moving on from this basic process, I want to talk about protections against eviction that tenants have. So there's 2 real things that I want to focus on right now, which are newer protections, particularly some that are in the city of Los Angeles. So first of all, I'm going to talk about the COVID-19 laws that have been going on for the last several years in different forms, and that many of you have heard about, and the fact that they are expiring. I also want to talk about some new protections that were passed by the city of LA and passed by the county of Los Angeles for certain parts of the county that protect people that are basically like a continuation of those old COVID laws that are now made permanent. So first of all, the COVID-19 pandemic protections. Really, like I said, I'm sure everybody's heard about these because they've been all over the news. They've taken many forms since the pandemic started almost, 3 years ago now. And so there have been laws passed by the federal government, by the state government, and in different forms, like I said. But the ones that have lasted this long are the rent protections that were passed by the city of Los Angeles for their residents, and then the county of Los Angeles for everybody else who doesn't live in the city of LA, but somewhere in the county. So both of those laws are now expiring. What they did before was they allowed tenants who couldn't pay rent because of the pandemic, because maybe they lost their job or a family member was sick with COVID-19, some reason similar to that. It allowed them a period to pay back their landlord, like for a year, for instance, and avoid an eviction. Those protections are expiring at the end of this month. What that means is that people who weren't able to pay before March 31st, the end of this month, may still be protected, but anybody who can't pay rent going forward for the months after, starting in April, are no longer have these COVID-19 protections anymore. Basically, as a tenant, even if you've lost your job due to COVID, starting in April, at least you have to pay your rent on time. So like I said, also though, any previous rent that you had not paid due to COVID will be due. Usually it's a year after whenever that rent was due originally. So if it was due in February of this year, it would be February of next year. If it was originally due in September of 2022, it would be due this coming September, 1 year later. There are some more specific dates for the city of Los Angeles, though. It's a lot to remember. And so this is another situation where you can either contact the LA Housing Department or contact our firm, and we can talk through it with you. But for the city of LA, any rent that was owed between October 2021 and January of this year, so January 31st, 2023, will be due next February in 2024. So it doesn't matter when it originally came due, as long as it fell within that period, it's going to be due in February of 2024. But so that's how those are expiring. So just to review really quickly, how does this affect you? Starting in April, a tenant has to pay all of your ongoing rent, or the landlord can start an eviction case against you. Any rent that a tenant might, and this means regardless of whether or not there's a COVID reason you can't pay it, you have to pay that rent on time, or the landlord can start an eviction case. Any rent owed before April of 2023, so this next month, as if it was related to COVID, you might still be protected by those old laws. And so that money just has to be paid by whatever deadline. So generally it's a year later, or if it's in the city of LA, it's that later deadline I told you of February 2024. There's that period of time. And then after that, if the money's not paid, the landlord can start an eviction case against you or the tenant. So that's what this means. If this applies to you, if you are affected by COVID and that's why you couldn't pay rent for any of these months, you contact NLS. NLS is our firm, of course, or some other attorney, and get some advice on whether or not you might be protected. But we're moving away from those laws and they're expiring. So that's the first set of protections. The second set is the just cause eviction protections. So there are two new laws that just passed in the last few months and that apply within the city of LA to all residents of the city of LA, and that apply to all people who live in unincorporated portions of the county. So I think the majority of people who are here tonight are probably residents of the city of LA. But there might also be some people from some of the neighboring cities like San Fernando, or maybe even Santa Clarita or Burbank. Other cities that are not the city of LA and not unincorporated county do not have these same protections. So they might have just cause eviction protections, and I'm going to explain what those are in just a second. But only in line with the state law. So only for people who live in multifamily houses with multiple tenants living, renting out different units in the building, that are more than 15 years old. Only for those people in those cities. Okay, so we'll review this in just a second, but I just wanted to lay out who this will apply to. So what does it mean to have a just cause eviction protection? Basically, like I said at the beginning of the presentation, under state law, the landlord can decide at the end of a lease that they just don't want to rent to you anymore. They don't have to state a reason. When there's a just cause eviction protection, so if this law applies to you, the landlord does have to state a reason. They can't evict you unless they do. And it can't be any reason, it has to be one of the approved reasons in that law. So, like as it says in the slide, it has to be a good reason. And so a good reason can include for cause evictions, which is situations where the tenant is done something wrong, is at fault. And this is going to be some of the examples I gave at the beginning of situations where an eviction can happen because the tenant might have done something wrong. It can also be situations where the tenant hasn't done anything wrong, and the landlord the law has given the landlord certain rights to evict tenants for specific reasons. These are called no-fault evictions, and I will talk about what those are. I'll give you some examples in just a moment. But first, to review really quickly, these are situations, for cause evictions, where the tenant is at fault, that are where the landlord is allowed to start an eviction case. So the biggest one, of course, is non-payment of rent, where the tenant hasn't paid their rent on time. Like I said earlier, nuisance cases or situations where the landlord is claiming that the tenant violated their lease, broke a term in the lease. Those are also situations where the tenant is at fault. There's a couple other ones. I mentioned also, committing criminal activity on the property could be one reason, where the landlord claims that the tenant isn't allowing the landlord to access the property, or is refusing to sign a new lease that the landlord's offering them that has the same terms as the lease before, or very, very close to the same terms. These are all reasons that the landlord might be able to say that the tenant has done something wrong and therefore should be evicted. But these are the ones where the landlord can say that the tenant hasn't done anything wrong, but still should be evicted, so they're not at fault. So some examples of this one are when the owner wants to live in the apartment and are actually going to do so. So they can't just say that they're going to do that. They actually have to do it. And it's not just the owner, but it could be the owner's spouse, partner, domestic partner, children, grandchildren, or grandparents. This does not include, at least in the city of LA, it does not include anybody like uncles, brothers, nieces, nephews. It has to be one of the people in this list. So that's one reason. Another reason is that the owner might want to just stop renting the apartment to anybody entirely at all, and permanently too, which means for at least 10 years. So if the owner goes through the right process and they just say that they no longer want to rent out this property at all, they can also evict the tenant for that reason. There might also be a reason where maybe the property is uninhabitable. It's in such bad condition that the government, like a government agency, says that nobody can live there. Effectively, that means that the owner has to evict the tenant, and they're allowed to in that situation as well. The owner can also evict a tenant if they want to renovate the property. That's another approved reason, or demolish it completely, destroy it. So the landlord can evict in those situations. However, if they choose to, at least in the city of LA and some of these other places, if they choose to, then the tenant might be entitled to relocation assistance. Basically means that this means that if the landlord wants to evict for one of these reasons, they have to pay the tenant money. How much money they have to pay them depends on where you live. But I'll use the city of Los Angeles as an example. This is the higher amount. So for tenancy, for somebody who has lived in the apartment for less than 3 years, and I don't just mean a person, but a whole household, then the landlord has to pay them $9,200. Or if somebody in that household is disabled or elderly, or if the household has young children, the landlord has to pay them $19,000. It's a little bit higher when the tenants have lived there for more than 3 years, as you can see from this slide. Or if the household is under a certain threshold, then they're considered low income. Then the numbers are $12,000 and $22,000. So there's a couple exceptions to this, but basically this is money to allow the tenants to find a new place to live because they didn't do anything wrong and it's not their fault they're being evicted. So how does this affect you or a tenant in general? If you live in one of these places, the city of LA or unincorporated LA County, then the landlord can only evict. This applies to everyone in those places. The landlord can only evict if they state one of these permitted reasons. The tenant cannot be evicted just for no reason at all. Even if you live in the city of San Fernando or one of these other places I mentioned that are not covered by those laws, you still might be protected by just cause, meaning that the landlord can only evict if they state that permitted reason. There's just additional requirements as to how old the building is and some other things like that. So it may still apply to you. You should consult an attorney if that's what's happening and get advice on whether or not you are protected by these laws. The other thing it could mean is that if the landlord chooses to evict for a no-fault reason, for some reason that you didn't do anything wrong as a tenant and you are protected by these laws, you may also be entitled to a payment of relocation before the landlord is able to evict you. I gave you an example of the city of Los Angeles. Under some of the other laws, it might be a lower amount. So not all of them are as much money, but you might still be entitled to some relocation funds to allow you to hopefully move to a new place if you have to. One final protection against eviction. This applies, as you can see in the red words, it applies only to tenants in the city of Los Angeles. It applies to everybody in the city of Los Angeles who's renting, and then in portions of unincorporated LA County, people who live in LA County but are not part of any city officially. In this situation, the landlord can only evict you if you owe more than 1 month of what's called fair market rent. Now, this is complicated to figure out what this is because that's how the law was written. So if people have questions, that's fine. I'll answer them at the end. But it doesn't matter how much your actual rent is. It just matters how much the fair market rent is. And these numbers that I put on the screen are what fair market rent is. It's set by the government. So if your rent is more than this, it's based on how many bedrooms are in your apartment. If your rent is more than this, then this protection might not help you very much. But for people who live in a 1-bedroom, for instance, and owe less than $1,747, the landlord actually cannot start an eviction case against you in these places. If it's a 2-bedroom, that number is a little bit higher. It's $2,222. So this is also a brand new law that started just in the last 2 months, last month, I believe. And so I don't think a lot of people are aware of it. But this can help people who only owe a little bit amount of money to give them a chance to pay that back without facing an eviction immediately. Okay. This is a good time to talk about the last subject. I don't want to bombard people with too much information. But the last subject is protections against rent increases. This doesn't apply to everybody, but there are some places where people have caps on the rent. And this doesn't mean that the landlord can't raise it at all forever, but it does mean that they are limited in how much they can raise your rent. And it also might mean how often they can rent. They are limited in how often they can raise your rent. So typically what that means is the landlord can only raise your rent once a year under most of the laws. Sometimes they can only raise it twice a year, but there's a limit either way on how much within that year they can raise your rent. So usually it's a percentage of what your rent is. So really quickly, it's just like the last one. It's a little bit confusing, but to know whether you're protected by a rent cap, you have to know where you live, and you have to know a little bit about when your building was built. You might not know this information on your own, although you might have a sense of whether or not your building was built before 1995, for instance, if it's an older apartment building or home. But if you don't know, you can call our firm, you can call other like legal aid firms or other attorneys, and they can help you find this information so you know whether you're covered by this. So in the city of Los Angeles, just so you know, if the building has to have been built before 1978, And there has to be at least 2 or more units on the property. So it doesn't protect people who are renting out just a single family home. But 2 or more units on the property could include somebody who's renting out maybe a house in the back, or even renting out portions of the home. So if there's 2 or more households renting out half the home because it's been split in half, or somebody's renting out the garage, for instance, that can be a situation where even if it's a single family house, there's 2 or more units on the property. That same requirement applies to the people who live in unincorporated parts of the LA County, and the date is different as to when it needs to be built. As I talked about earlier, in other cities like San Fernando, Santa Clarita, Burbank, and so on, it's actually more generous in that it covers whether or not the building, only if the building is 15 or more years old. And so that just changes all the time. It's 15 or more years from today, whatever day today is. So it covers newer buildings than the other laws, although there are some other restrictions on that. So like I said, if you have questions about whether this applies to you, contact us or another attorney or legal services agency, and we can help you find this information. So what that means, though, is if you are in the city of Los Angeles and you meet those requirements, right now, the rent increase cap, meaning your landlord cannot raise your rent more than at all, actually, so 0%. Until 2024. That number will change every year, but at least for this year up until 2024, it's 0%. So the landlord cannot raise your rent at all if you live in the city of Los Angeles and meet these requirements. For the people in parts of Los Angeles County that don't have a city, that's 3%. And then anywhere else, the other places that I was talking about, like San Fernando and Santa Clarita, it's a complicated formula, but basically it's always going to be between 5 and 10%. And this year it changes every year, but this year it actually is 10%. So it's a much higher number this year. But in the past it's been 5%. So it changes based on basically how the economy is doing and whether there's inflation. So it's not just that the landlord can raise your rent a certain amount, but they have to do it the right way as well. So they have to give you the right amount of notice, and how much, meaning that it has to be in writing as well. So they have to give you a written paper, and they have to give you enough time for you to prepare for the rent increase. So if their increase is less than 10%, which for most people it is, then the landlord only has to give you 30 days. But they do have to give you 30 days and in writing. They can't just walk into your apartment or knock on your door and say they're increasing the rent. It has to be in paper. They also can't text it to you or just send you an email. They have to give you a written notice that they're increasing your rent, and 30 days time. So one more example, if they give you this notice in the middle of February, on February 15th, then they can't raise the rent until not March 1st. They have to wait all the way until April at that point to make sure that they give you 30 days of notice. If the increase is more than 10%, so a larger increase, then the landlord can't give you just 30 days. They actually have to give you 90 days of notice before the rent can actually go up. Finally, one last thing to make you aware of, for people who aren't protected by any of these rent protections that live in the city of Los Angeles. So if your building's newer than 1978, because that was one of the requirements, or you live in a single family home, you do still have one additional protection, which is that if the increase is more than the same amount as under that other law, so 5 to 10%, this year it's 10%, then the tenant, whoever might be entitled to relocation assistance. This is just the same kind of situation like if you're being evicted for a no-fault reason. You didn't do anything wrong. The increase is too high, and so you might still have to move out, but the landlord has to pay you this money that, and it varies. It's the same amounts as in the other slide, $9,000 or $19,000, depending on who's in your household. But they'll have to pay you that relocation assistance before you leave. So there are protections for people, at least in the city of Los Angeles, who have large rent increases, even if they don't have a rent cap that protects them. So to review really quickly, how does the rent cap affect me or a tenant? So first of all, you should always, if you get a rent increase notice, always check first to make sure your landlord gave the right notice. Did they put it in writing? If they didn't, then they might not be able to increase your rent. Did it give the right amount of time? Did it give the 30 or the 90 days, as they're required to? If they didn't do that, if they're trying to put the rent increase in 20 days instead of 30, then it's not going to be valid and the landlord will have to start over with a new notice. Second, assuming they've given you the right notice, check to make sure that your landlord raised the rent by the right amount. So, like I said, you might be protected by a rent cap. Right now in the city of Los Angeles, if you are protected because your building was built before 1978, then the landlord might not be able to raise the rent at all. If you live somewhere else, it might be limited to only 3% of your rent or 10% or something like that. So make sure that the numbers add up. If they raise it too much, it's not a valid rent increase. It won't count, basically. And then lastly, and I think most importantly, if you have any questions about any of this, because it can be a tricky process finding out when your building was built, finding out how many units are really on the property, trying to calculate how much the rent was, contact an attorney for assistance. We're there to give you advice. We gave our number at the beginning. I'm going to put it up on the screen now. A couple of different places you can contact. So first of all, NLSLA is us. That's our phone number that you can call for intake, and our website. You can also contact Stay Housed LA. They help connect you to other attorneys who can assist people under a certain income threshold if they're facing an eviction. So people that haven't just received a notice but have received court papers can contact Stay Housed LA, and they'll help try to assign you an attorney from not just our firm, we're one of them, but from other firms as well. Finally, if you just have questions and want some more information about some of these protections, and you don't call us, you just want to look at our website or contact the city directly. The Los Angeles Housing Department has a ton of information for people who live in the city of Los Angeles, explaining, giving you stuff you can read about these same protections that I just talked about, answering some of your questions. You can even file complaints with them for certain types of things that your landlord does that violate these protections. So this is their website. Go there and you can find out more information about some of these protections as well. With that, I think we're going to transition to see if there's any questions in the chat, and happy to talk more. So thank you.
Michael, can you see the questions in the chat?
I can now.
If not, I can read them to you.
Yeah, if you don't mind, just so I can catch up.
Yeah, so the first question is, can landlords give you a 5-day notice to vacate if they are selling the house, or do they have to provide 30 or 60-day notice?
So in fact, if they're selling the house, they can't just give you a notice. If you're protected by just cause protections, of course, they can't just give you a notice saying that they're selling the house. That's actually not one of the approved reasons for an eviction. The landlord would have to have some other reason. So they'd have to claim that they're moving their family into the house. But let me back up for a second. If the landlord sells the house, the new owner that buys it has to take you on as a tenant. That just is part of the deal. And so the new owner then can purchase the house and then try to evict you for one of the other reasons. So maybe they want to take it off the market and they no longer want to rent it out. They just want to live in it. That might be a valid reason. And in that situation, they'd have to give a 30-day notice, I believe. But there is no, if you're protected by one of these laws, there is no right for the landlord to just say, I want to sell the house and you need to move out. They have to have one of the reasons I listed.
Great, thank you. Second question, are the relocation funds that you talked about, are those on a per person basis or per family or the household?
Those funds are for the whole household. So if there's multiple like family members, it'll be split between the family members, however that works. Or if there's multiple roommates, for instance, it would be split. It just applies to the whole household. But that's where if you qualify for that higher amount, that also applies to your whole household. So even though you as the lead tenant may not have a disability or be a senior citizen, If anybody in your household is, that'll qualify for the whole household for the higher amount.
Okay, next question. You talked about the limitations on rental increases. I believe it's 10%. When did those restrictions go into effect? Mary asks, because a friend of hers was increased $800 last year. She doesn't tell us what the rent is, and charged a new $4,000 deposit.
Well, some of the restrictions are old and some are new. So it depends, and they might not apply to everybody. So like I said in the slide, those restrictions only apply to not everybody in the city of LA, but only to people in certain buildings that are older than 1978, that have multiple units on it. So it's hard to answer that question directly, at least in relation to your friend. But the rent restrictions for those buildings in the city of LA have been around since 1978. The ones for the county that I was talking about, and as well as the ones for some of those other cities in Santa Clarita, for instance, those are more recent. They started in about 2000. I think they both started in 2020. So it varies.
Okay, great. This question, not quite sure. Maybe Myra can explain a little bit more. She's asking, what about Sylmar? And I'm not sure if this means some of the restrictions you were talking about, if it's covered. Does it cover like San Fernando or Santa Clarita, or Santa Clara? Santa Clarita, which I guess are separate cities.
Yeah, those are separate cities. So Sylmar is not its own city. Sylmar is, it could be part of the county or the city, but I think typically Sylmar is completely within the city of LA. I'm not sure. So if your address is Sylmar, you're most likely covered by those city of Los Angeles laws. But if you're not sure, because your postal address doesn't necessarily tell you what city you're in, or if you're in the county, if you're not totally sure, you should, again, contact an attorney just to make sure, or the LA Housing Department to get an answer on that.
Great, thank you. Julissa, the next question from Maria, can you read that or translate that for Michael?
Yes, of course. The question in Spanish reads, ¿Qué ley protege a los inquilinos de las casas o departamentos construidos del año 2020 hasta ahora? Vivo en San Fernando. It translates to, what law protects tenants of houses or apartments built in 2020 so far? Or I live in San Fernando.
If you live in San Fernando and your apartment was built in 2020, there may not be one of these laws that protects you. You might also not be in the city of San Fernando, though. It's not always totally clear where the boundaries are drawn, and people might be in a city they don't realize. San Fernando being surrounded basically by the city of Los Angeles. So I won't say that it doesn't apply to you, but just to be in general, if you live in the city of San Fernando and your building was built in 2020, you won't be protected by one of these laws. You still do have some protections. The landlord can't discriminate against you. They can't retaliate against you. That applies to everyone. But these just cause protections or the rent caps probably won't apply to you.
Thank you. This may be a question better suited for contacting our office directly, but Michael will give it a shot. This is from Paula regarding rental deposit. The lease doesn't include wear and tear provision. Is it legal for the landlord to charge me for painting the unit after I let it go? My lease agreement says I have to pay for any damages, but my unit has no damages. The walls are just wear and tear.
So yeah, that is hard to answer completely without giving more personal advice. And so I'd recommend you call us or another attorney for a real detailed answer. In general, though, what I will say is the lease doesn't have to provide for wear and tear. That's a legal thing. So what that means is that the landlord can't charge you for regular wear and tear, regardless of whether that provision is in your lease. So it's possible that they may still be able to charge you for painting a unit, but it's not dependent necessarily on what's in your lease. That right would be a more general right.
Okay, Nellie has a question, and I see she just turned her camera on, so maybe she can amplify if I don't get it all right. So if a mom and pop rented an unpermitted guest unit and the tenant hasn't paid rent for more than 1 year, can the homeowner evict the tenant?
So the mom and pop refers to something different under the LA rent control law. So if I understand the question right, what you're asking is that, well, let me back up. So if the tenant hasn't paid rent, it doesn't matter if the landlord's a mom and pop or not. The rights don't change. The landlord can always evict a tenant if they haven't paid rent for more than a year, if there's some sort of agreement for their tenant to pay rent. But it depends. Obviously, it could be that there's protections related to COVID that might be what come into play here, since that law is only just expiring this month. And so unless you have more specific information and you want to clarify on that, I'm not sure I can answer much more without getting into like specific advice about a specific situation.
Okay, thank you, Michael. Next question. How do the rent caps differ on single family homes built in the 1950s versus apartments? And I don't know if that means apartments that were built in the 1950s. That's from Mary.
The main difference between single family homes and apartments is that it doesn't matter if it's a single family home necessarily. What matters is how many units are on the property. So if they're apartments, that implies that there's going to be more than 2 units on the property automatically. I would just assume that. If it's single family homes, it could be that it's just the home and somebody's just renting the whole property, in which case the rent cap isn't going to apply no matter when it was built. Or it could be that I kind of gave the example of a situation where a single family home might still have multiple units being rented out, even though it's a single family home. So one of the examples is if the homeowner has like one of the separate, like a back house, a mother-in-law unit or whatever, the term is for them. That could be a situation if they're renting that out, now there's 2 units on the property. If they're renting out their garage, or if they've split the house in half and they're renting out half the house or some bedrooms, that can still mean that there's 2 units on the property, even though it's a single family home. So the fact that it's built in the 50s means that it could be subject to the rent caps in the city of Los Angeles, at least, because it's old enough. The real question at that point is how many units are on the property. It doesn't necessarily matter what it's classified as. It matters what the landlord's actually doing, how they're using the property. I'll take the next one because it seems like it's going along the same lines. The next question is, does it matter if the rented unit is permitted or not permitted when evicting the renter? It can matter in general terms, but at least as far as whether the protections apply, it doesn't matter if it's permitted or not. The tenant can still be protected based on how the landlord is using the property. So if the landlord is renting out several unpermitted units on that property, like 3 of them, that will still potentially qualify the tenant for rent caps or some of the other protections. So it doesn't matter. It doesn't help the landlord that it's unpermitted. The tenant protections apply nonetheless.
Okay, there are no other questions in the chat. We've got a couple more minutes, so if anybody has any other questions, please go ahead and post them.
Yes, we have a few questions that we received in advance from community members, so I'll go ahead and just read out the first question.
Sure.
The first question is, depending on your lease agreement, do tenants' rights change from case to case?
Potentially, yeah. Now, these protections about just cause, those don't change. So that can be the same across the board. But what changes is the situation I was talking about earlier, where if the landlord wants to claim that you violated the lease and use that as a ground for an eviction. So every lease is different. Not every lease, for instance, prohibits pets. The landlord, if your lease prohibits pets, then the landlord can evict you and claim that if you have like a dog or a cat, that you violated the lease. But if your lease doesn't have that clause, they can't evict you based on that. They can't. There's no right for them requiring you to not have pets. The same would be the number of occupants, having guests over, other types of things like that the landlords might use to base an eviction on. Those things can only come out of the lease requirements. Another one that comes up sometimes is rental insurance. There is no state law requirement requiring a tenant to have renter's insurance. That only comes from the lease. So in those situations, and really only those, because the rest are pretty standard, it can vary from lease to lease.
Thank you. And the second question is, what would constitute an unlawful eviction?
Well, I guess it can mean anything, a lot of things. But typically when we talk about an unlawful eviction, we're talking about a situation where the landlord has not waited for the sheriff to change the locks. They've done it themselves. So if they change the locks, they take your key, they change the locks on the building so you can't get in, or maybe on the gate, if the gate is your access to your apartment, that can be an unlawful eviction. Could also be a situation where I was talking about utilities. So if the landlord interferes with your water, cuts off your electricity in an attempt to move you out, that can be considered an unlawful eviction too, because they're trying to convince you to move out without going through the right process.
Okay. And the next question is, are there any restrictions on rent increases? And are there any restrictions on how frequently it can occur in a year?
Yes. So the restrictions are the ones I talked about. It depends on where you're living. I didn't talk as much about how frequently they can occur. So under state law, no. Generally, there's not any protection against that. The landlord could increase your rent every month if they wanted. However, here, I think for everybody, I would assume in this call, you live in one of the cities that are somewhat protected. So the city of Los Angeles has some protections on rental increases. The county of Los Angeles as well. So if you're subject to one of those rent caps, then both the city and the county limit it to one rent increase per year at that amount. The state law one, the one that applies to San Fernando and Santa Clarita and other cities, provided that your building is covered, so it's more than 15 years old and has more than one unit on the property, they can only raise it twice in a year, and only totaling the total amount. So they can't raise it for 10% two times. They can only raise it for 10%, a total of 10% across those two times. Hopefully that makes sense.
Thank you. And last question is, what specific eviction defense services does Neighborhood Legal Services offer?
Yeah, so our firm, like a number of others in the area, offers eviction defense services to people under a certain income threshold, so people considered low income. So generally that's based around the poverty line, what's considered by the federal government to be the poverty line. But we're part of that other group, the Stay Housed LA, which I put on the very last screen, and they have higher income amounts, and so we can represent even families who might be considered middle class as well. And so the types of services we provide range across the gamut. We provide advice to people who are facing eviction. We provide advice to people who are not facing eviction but think they might be at some point. If you get a notice, we can give you advice on like how to respond to a 3-day notice or to your landlord. If you get a court case, we have self-help services in many of the courts. We will actually represent, not every tenant, but we represent tenants in eviction cases, and we'll defend you and appear in court on your behalf and argue your case and do your trial. And so the whole range of the services, even people who have missed the court papers and only get that notice to vacate, meaning the sheriff's coming, there are some situations where we're able to help them as well and file papers with the court and try to stop the eviction, and give you a chance to participate in the case. So the whole range of eviction services is what we provide.
I'll also just add that in addition to all of the eviction services that Michael just went over, we also assist tenants who are not facing eviction but may have issues with their landlord. If they have habitability issues where they have mold problems or bugs or whatever it may be, we provide services in those areas, along with help with if you have questions about a Section 8. If you're a Section 8 voucher holder or other vouchers, we can provide services and assistance in those areas as well.
And the last thing is that we're not just limited to eviction services. We provide a whole range of services for workers, for consumers. We provide access to healthcare questions. We help people who are trying to access public benefits, people who might be survivors of domestic violence and need services connected to that. We have a disaster relief team as well, which helps out in those situations. So we provide a lot of services to people that are just not just eviction.
Those are all the questions for tonight.
Great, thank you. So I want to thank Assemblymember Rivas and her staff, especially Julissa and Jessica, for all of their help in putting this workshop together. I want to thank Lindsay for doing our interpretation, and I want to thank Aaron of our staff for assisting on the technical side, and most importantly, to Michael Novosky for all of his helpful information today. And for those of you, as he said, for those of you who have questions that were not answered today, whether they're on housing or any other legal issues you may have, please contact Neighborhood Legal Services. If you didn't get the either our phone number or our website information, if you reach out to Assemblymember Rivas's office, they will put you in direct contact with us. So with that, I'll say thank you. Have a great evening, and we look forward to another one of these workshops with the Assemblymember's office.